Breaking news tonight: Supreme Court has just delivered a 6-3 decision that could completely redefine the fight over gun possession in America. The ruling is already shaking the political landscape, with the Department of Justice signaling immediate resistance to the court's move. This isn't just another legal battle, it's the next chapter in a constitutional showdown that's been building since the landmark Bruen decision. 6 justices have drawn a clear line in defense of the Second Amendment, while 3 stand firmly opposed, and the clash between the court and the DOJ is only getting started. So what exactly did the Supreme Court decide, and why is the federal government already pushing back? Stay tuned, because this ruling could reshape how the Second Amendment is enforced, challenged, and defended across the nation. This case didn't just appear out of nowhere. It's been building for years, winding its way through the federal court system like a powder keg waiting to explode. At the center of this legal firestorm was a long-standing challenge to federal restrictions on firearm possession, restrictions that many Second Amendment advocates argued were blatantly unconstitutional and violated the core principles that our founders enshrined in the Bill of Rights. For years, lower courts had sided with the government, repeatedly upholding these possession limits and essentially giving federal authorities broad power to determine who could and couldn't exercise their constitutional right to keep and bear arms. But gun rights organizations refused to give up. They appealed and appealed, taking their fight higher and higher through the judicial system, arguing that modern interpretations of the Second Amendment had strayed dangerously far from the text and history of the Constitution itself. After multiple appeals and mounting pressure from advocacy groups, the Supreme Court finally agreed to take up the case, setting the stage for what would become one of the most closely watched constitutional battles in recent memory. At the heart of this case was one fundamental question that cuts to the very soul of American liberty. Can the federal government impose sweeping restrictions on firearm possession without clear constitutional grounds rooted in our nation's history and tradition? And with today's ruling, the court just gave its answer, and that answer is reverberating across the entire country. In a 6-3 majority opinion that's already being called a landmark moment for constitutional clarity, the justices ruled that the current federal possession restrictions went far beyond what the Constitution actually allows. The court emphasized, in no uncertain terms, that the Second Amendment's text and history simply do not support the kind of modern-day interpretations that have been used to expand federal authority over gun ownership. Writing for the majority, the court made it crystal clear that when it comes to fundamental rights, the government doesn't get to rewrite history or cherry-pick precedents to justify restrictions that our founders never intended. The opinion methodically dismantled the government's arguments, pointing out that the regulations in question couldn't be reconciled with the historical tradition of firearm regulation in America. Now, to be clear, this isn't a total free-for-all for gun owners. The court acknowledged that certain narrow, historically grounded restrictions can still pass constitutional muster. But what this ruling does is draw a bright line in the sand, telling the federal government that it can't simply invoke public safety concerns to justify whatever gun control measures it wants to impose. It's a massive step forward for those who've been arguing that the Second Amendment has become a second-class right, subject to restrictions that would never be tolerated if applied to freedom of speech or religious liberty. Legal scholars are already calling this a direct extension of the Bruen framework, reinforcing the principle that history and tradition, not government convenience or political preferences, must determine the scope of our constitutional rights. Now let's talk about the split, because this 6-3 division tells us everything we need to know about how deep and intense the fight over gun rights remains, even at the highest level of the American judiciary. The majority included the court's 6 conservative-leaning justices. Chief Justice Roberts, along with Justices Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. These justices formed a solid bloc, united in their interpretation that the Constitution's text and our nation's historical tradition must guide Second Amendment jurisprudence, not modern policy preferences or fears about public safety. On the other side, the three liberal justices, Sotomayor, Kagan, and Jackson, issued a strongly worded dissent that pulled no punches. They warned that this ruling could fundamentally undermine public safety, arguing that the majority was ignoring the realities of gun violence in modern America and handcuffing lawmakers who are trying to protect their communities. The dissent painted a stark picture of potential consequences, suggesting that this decision could lead to more firearms in dangerous hands and tie the hands of law enforcement. But here's what the majority fired back with, and this is crucial: constitutional rights are not subject to fear or politics. Now here's where things get really interesting, and frankly, a little concerning depending on which side of this debate you're on. Within just hours of the Supreme Court releasing this decision, the Department of Justice issued a carefully worded statement expressing what they called serious concern about the ruling's implications. But it wasn't just hand-wringing. Sources inside the DOJ are reporting that officials are actively exploring ways to limit the impact of this ruling, looking for angles and workarounds that might allow them to keep current regulations intact even in the face of this Supreme Court rebuke. They're reportedly considering everything from rewriting enforcement guidelines to crafting narrow exceptions that they hope might survive judicial scrutiny. Some legal observers are even suggesting the DOJ might attempt to relitigate certain aspects of the decision by bringing cases that test the boundaries of what the court said. In other words, the Department of Justice is not backing down. They're digging in, preparing for what looks like yet another constitutional standoff between the executive branch and the judiciary. And this raises some really troubling questions about the separation of powers and whether federal agencies are willing to accept decisions from the Supreme Court that they don't like. Gun rights advocates are already crying foul, arguing that the DOJ's reaction amounts to defiance of the highest court in the land. Meanwhile, gun control supporters are applauding the DOJ's resistance, saying someone needs to stand up and protect public safety even if the court won't. The battle lines are drawn, and this fight is far from over. The political fallout from this decision is spreading like wildfire across the entire country, and the reactions couldn't be more polarized. Conservative leaders and Republican lawmakers are absolutely hailing this decision as a triumph for liberty and constitutional governance. Statements are pouring in from red state governors praising the court for standing up for the rights of law-abiding Americans and pushing back against federal overreach. Social media is exploding with celebrations from Second Amendment supporters who see this as vindication after years of fighting in the court. But on the other side, the reaction is one of alarm and defiance. Governors in states like California, New York, and Illinois have issued dire warnings, with some claiming this decision could roll back decades of safety progress and put their citizens at risk. We're already seeing emergency legislative sessions being called in blue states, where lawmakers are scrambling to figure out how they can craft gun control measures that might survive under this new legal framework. Attorney generals in multiple states are holding press conferences, vowing to defend their existing gun laws and promising to find ways to work around this ruling. And here's the thing: both sides are already preparing for the next round of legal battles. Gun rights organizations are identifying laws across the country that they now believe are vulnerable under this decision, and they're preparing to file challenges. If you're part of the Second Amendment community, you already know that today feels like a major victory, and the reactions from major gun rights organizations reflect that sense of triumph. The Firearms Policy Coalition wasted no time in releasing a statement calling this decision a historic moment of correction, arguing that the court has finally begun to undo decades of judicial negligence when it comes to protecting the right to keep and bear arms. Their statement emphasized that this ruling reinforces what Second Amendment advocates have been saying all along, that the Constitution means what it says, and modern governments can't simply wish away rights they find inconvenient. Gun Owners of America went even further, releasing a fiery statement declaring, "The Supreme Court has reaffirmed what we've known all along. The Second Amendment is not a second-class right." They're calling on Congress and state legislatures to take note and start repealing gun control laws that can no longer survive constitutional scrutiny. The National Rifle Association, while dealing with its own internal challenges, also praised the decision, with officials stating that this ruling represents a major step toward restoring the founders' vision of an armed citizenry capable of defending themselves and their liberties. But let's step back from the political battlefield for a moment and hear what legal experts and constitutional scholars are saying about this decision, because their analysis provides crucial perspective on what this ruling actually means for the future of Second Amendment jurisprudence. Prominent legal analysts across the ideological spectrum are calling this a landmark clarification of the Bruen decision, essentially taking the framework that the court established back in 2022 and applying it with even greater force and clarity. Constitutional law professors are noting that the court is sending an unmistakable message to lower courts. Stop trying to find ways around Bruen, stop inventing new tests or historical analogies that don't actually hold up, and start taking the Second Amendment as seriously as you take other constitutional rights. What makes this particularly significant, according to legal scholars, is that it reinforces the principle that history and tradition, not government convenience or contemporary concerns about public safety, must determine the scope of constitutional protections. So what happens next? That's the question everyone's asking, and the answer is that we're entering a new and uncertain phase in the fight over gun rights in America. The immediate next step is how lower courts across the country interpret and apply this decision. Federal district courts and circuit courts of appeal are now going to have to go back and reconsider cases that have been pending, cases involving everything from magazine capacity limits to waiting periods to registration requirements. Gun rights organizations are already compiling lists of laws they believe are now vulnerable under this new ruling, and you can expect a wave of legal challenges to be filed in the coming weeks and months. Challenges to state-level assault weapon bans, restrictions on where firearms can be carried, background check requirements that go beyond historical norms, all of these could now be back on the table, with plaintiffs pointing to this Supreme Court decision as controlling precedent. Meanwhile, state legislatures in gun-friendly states are likely to move quickly to repeal or amend laws that no longer seem defensible under this framework, while states with strong gun control traditions are going to try to craft new regulations that they hope can survive judicial scrutiny by finding more creative historical analogies. Tonight's decision represents a genuine turning point, but let's be absolutely clear about one thing. This is not the end of the fight over gun rights in America. Not even close. What the Supreme Court did today was issue a powerful statement about constitutional limits on government power, reminding federal and state authorities that they can't simply override fundamental rights because they think it would make society safer or because public opinion polls suggest people want more gun control. The court just told the political branches that constitutional rights don't depend on political moods, election results, or shifting cultural attitude. They depend on text, history, and tradition, and those things don't change just because the times do. So stay tuned, stay alert, and make sure you're subscribed to this channel, because this story is far from finished. We're going to be following every development, every new court case, every political response, and every twist and turn in what promises to be one of the most consequential constitutional battles of our generation. The Supreme Court has spoken, but the fight for the Second Amendment continues, and we'll be here to bring you every update as this story unfolds.